Public Defender Natalie Pate, and on behalf of Mr. Grimes, who stands to my right, please state your name for the record, sir.
Teresa Claire on behalf of probation. Your Honor, Mr. Grimes is before the court for a violation of probation hearing. Mr. Grimes was sentenced in this case in September of 2015. He was originally given a heightened sentence that was revoked back in 2016. Since that time, Your Honor, Mr. Grimes is still in violation of any of the court's orders. In that he has a balance of $1,503. He did have a payment that was made to the court in April of 2023. However, that was due to a garnishment that the court had set out. There is a balance of that of restitution that is $265.05. Mr. Grimes failed to report to probation, failed to complete the class, failed to complete 25 hours of community service, failed to provide proof of his GED, failed to provide proof of employment. He also has new pending cases, 1 out of 42. That's a domestic violence alleged date of offense of November 7, 2019. He has a pretrial in that matter on the 27th in 2 days. He also has a pending case out of 14B, an aggravated assault, an alleged date of offense of May 31st, 2024. He has a pretrial in that case in July 25th of 2024. Given the non-compliance by Mr. Grimes, probation is recommending 93 days in jail with credit for 13 days served, that he served the balance, waive remaining terms, accept his financial obligations, and discharge him from probation.
Thank you, Your Honor. I did have the opportunity to discuss both the alleged violations of probation as well as the recommendation with Mr. Grimes. He does acknowledge the violations of probation. Our request at this time is for the to respectfully request the court to considering discharging him from probation without improvement. Of course, still imposing the financial obligations. We are respectfully requesting the court to consider not remanding him today, as he did serve 13 days already so far for his violations. He does have full-time work, employed there full-time for 4 months. His 2 cases that are pending are misdemeanor matters and are still pending at this time. We are respectfully requesting the court to discharge him from probation without improvement and to not impose any additional jail time at this time.
Young man, anything you want to say?
I can pay 150 today if needed.
Pardon?
I can pay 150 today.
I'm not really worried necessarily about the money. I'm trying to figure out why you didn't do anything.
Yeah, I've just been all over the place. So, but I am trying to get them off my record. So,
Pardon?
I said I've been all over the place, but I am trying to clear my record. So that's what I'm here.
Mr. Valero, that date of offense on the domestic was in 2019, correct?
Correct, Your Honor.
And what, was he just on bench warrant stat? What?
I believe so. I can verify that for you.
And then you have well, she's looking at that. You have a brand new, while you're on this case and on a bench warrant on the other case, you got a new ag assault that you picked up on May 31st.
That's an alleged case, though.
What?
That's an alleged case, though. I was arrested for warrants. Just do that case.
I realize it's alleged. They're all alleged until you come to court to take care of it.
Yes,
but,
sir.
I mean,
Yes, he was on bench one stand. Sure.
jeez. All right. Anything else you want to say?
No, sir.
We're going to waive all remaining terms and set the financial obligations, discharge him from probation without improvement. Defendant is sentenced to 93 days in jail. I'll give him credit for 13. Defendants served a balance. Defendants remanded.
Damn, he going to jail. Damn, he going to jail. That's
Washington.
Sir, can you
hear me? Yes, sir. I can hear you.
I can hear you.
That was Mr. Washington.
That was Mr. Washington. Mr. Washington? You need to mute yourself and stay muted until we tell you not to.
Morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Washington. Ms. Washington, can you unmute and state your name for the record, please?
My name is DeMarcus Daquan Washington.
Your Honor, there are two files in front of you. One, he owes about $500 on, or $525, I think, 507. He paid a $500 bond. On the other one, I think he might owe $325, and he paid a $300 bond. He just got out of prison in the last couple months. He's just getting back to working. I'd ask that you just apply the.
Did he pay the bond? Because I had the bonds being set, but I don't have that he paid them.
I'm not sure. JAS just reflected that he paid bonds on both cases.
You see bonds on either? I see the bond set, but I don't see payment.
Well, if I misread JAS, I apologize. I'd ask then to adjourn the show cause so he's been in prison for 5 years, so he's kind of just getting back on his feet and back to work.
Are you working currently, sir?
Yes, I work at Deluxe Tents and Events in Belleville. And Judge Simpson, I just wanted to ask you, as you know what I'm saying, somebody who just did 5 years in prison. And you know, these cases are misdemeanors, and I did just get sent to prison from Washington County. I was wanted to know if you could run anything concurrent with the time I've just done, because I just came home May 30, 29th.
Sir, I don't have any proof that you did any time in prison. I don't have any of that in front of me.
Okay. Well, I'm saying
So I'm going to adjourn this to July 10th, 2024 at 9 a.m. Council, get together something for me to take a look at regarding that.
That's fair.
As well. Well, thank you. As well as in case if I decide that he needs to at least pay one of these, how he would do that.
Sure. Thank you.
Thank you.
So July 10th.
July 10th.
Okay.
And next, make sure that you understand how to work Zoom so you're not interrupting my court.
Yes, sir.
Thank you.
Then, y'all, they said I interrupted the court and everything, y'all.
Seriously? Kick him out. Just kick.
He's gone.
Yeah, they recorded everything, y'all. Yo. Really? Okay, go ahead. This is your motion.
Thank you, Your Honor. Today, the time set for a motion for reconsideration on reinstatement of conviction. To my understanding, the prosecutor did not have a response to this motion. I'll keep my allocution very brief. I know Your Honor has reviewed the motion. As Your Honor is aware, this honorable court reinstated Ms. Brooks' conviction back on May 14th, 2024. Under MCL 780.621H, a conviction automatically set aside may only be reinstated for two reasons. One being the conviction was set aside in error, or two,
that's not what you stated in here, right? Didn't you state that it was an and?
Yeah, and there has been a judicial termination
no, you put in your motion in paragraph 10.
Yes.
May only be set aside for two reasons. One, the conviction, and there has been a judicial determination. That's incorrect. It's not an and.
That is what is stated in the.
There are two sections under which it can be set aside.
Yes, there are, Your Honor. Under MCL 780.621H, the memo that May 4th, 2023 memo by the Michigan Supreme Court has stated, and I am reading from their memo, a conviction automatically set aside may only be reinstated for two reasons. One, the conviction was set aside in error, and two, there has been a judicial determination that the defendant has failed to make a good faith effort to pay restitution. That is pursuant
under that one section.
Yes, Your Honor. And this conviction was automatically set aside. And then
first of all, it was set aside in error. Had you looked at it, because it shouldn't have been set aside in the first place. But go ahead.
It was set aside. Ms. Brooks had been making payments on her statement. There was no judicial finding that there
Well,
was
I'll
no.
make the finding then, so we can get to the end of this, because I went through a lot in terms of Ms. Brooks, trying to make sure that she wasn't double dipped. I think that this motion for reconsideration, one, was filed in bad faith because of what happened in this case. And a motion consideration also is not entitled to a hearing unless the court does so, and unless it is requested that one, but I set it for a hearing. So here's what I will say. First of all, the conviction was set aside in error. I went through great pains to make sure that Ms. Brooks was not being double dipped. It turns out that two portions of the restitution that were owed were, there were two parts to it. One that was in the court, one also that was in part of a civil action. She elected to pay in full the civil action, has not made, in this court's mind, absolute good faith effort to pay forth this second portion. She has been making payments, but she could have certainly, with this action, elected the opposite. Hence, I would find that that's not in good faith. She's made her efforts, but I don't think in good faith has made the effort, and also has missed for significant periods in time, the payments that she initially had agreed upon to pay. So in that respect, and the court believes while she missed those payments, she could have made those payments, but did not. And so for those reasons, the court would find that the court doesn't believe that she's made a good faith effort. The motion for reconsideration is denied. You'll file an order to that effect for my signature.
Thank you, Your Honor.
Case, People versus Brandon Cole.
Assistant Public Defender Natalie Pate on behalf of Mr. Cole, who is approaching. State your name for the record, sir.
Brandon Cole.
Thank you, Your Honor. Today is the date and time set for sentencing. I have reviewed the pre-sentence investigation report with Mr. Cole. We have no changes, additions, or corrections. We would respectfully request to address the recommendation when appropriate.
Go ahead.
Thank you, Your Honor. I have reviewed the recommendation with Mr. Cole. Obviously, it is a jail recommendation. We are respectfully requesting the court to consider not imposing that jail sentence. Mr. Cole is gainfully employed at GDI Transportation. He shuttles patients around, as well as he further supplements this income with DoorDash. He provides for his 8 children. He does have the pending felony case, which to my understanding in reading the report is the reason for the jail recommendation. He's scheduled to be sentenced on that felony matter on July 16th. And I did discuss this with his felony attorney. There is no sentencing agreement in that matter, but we believe he is likely to be sentenced to probation on his felony case. He does reside with his uncle in Belleville and has taken some steps to get his 15th district bench warrant recall. He plans on walking in tomorrow for arraignments to get that recalled. Apart from these matters, the pending felony and this one, he does not have a criminal history. We are asking the court to consider not imposing the jail time. He is very dedicated to working on himself, providing for his kids, and he's even been looking into therapy as well as parenting classes as encouraged by his felony case attorney from our office. We are asking the court to not impose the jail time so it does not derail his progress. And further, he will be getting a lot of the programming necessary in all likelihood on his felony probation. Nothing further for me, Your Honor. Thank you.
Cole, anything you want to say? Case, People versus Brandon Cole.
Assistant Public Defender Natalie Pate with and on behalf of Brandon Cole again. Please state your name for the record, sir.
Brandon Cole.
This is when we were interrupted by the power. So go ahead. Anything else you want to tell the court?
Oh, yeah, I believe Mr. Cole was about to speak when the power was in. Go ahead, sir.
I was just trying to say, Your Honor, that I am sorry for my actions. I am a strong man, strong Black man, Christian man, and I am in seeking therapy right now. I have a lot of little ones that I do work for and take care of. I am a very important piece to them, and I'm trying to do better, Your Honor. I really am, and that's all I really have.
My problem is when I look at your prior arrest and convictions, the nature of those, and that you're currently on a bench warrant status at a 15 and an indecent exposure charge, all of that taken into consideration. It's the sentence of the court, $125 statutory fee, sentence the defendant to 90 days, Washington County Jail, credit 6 days served, defendants to serve the balance. Defendants remain.